he may have been coerced into believing that his company was going under by agents of Twitch.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
So then it's also been reported this week that PhantomLord has won part of his case against Twitch. You might remember that I believe PhantomLord was banned from Twitch, and now he is suing Twitch over the alleged violations of his contract, and I believe California state law and all that. This is in county court. This is in California, Santa Clara County. San Francisco County is where we are here. And you may have heard that he had a little bit of a win this week, and so I thought we should go over that, see what this win is all about. The parties have bifurcated an issue for bench trial. Closing briefs dated September 20th were delivered on September 23rd. This is my proposed statement of decision. The parties are plaintiff and cross-defendant James Varga and defendant and cross-complainant Twitch Interactive. Let's cut it out with the cross-complainant and cross-whatever. The plaintiff is James Varga and the defendant is Twitch Interactive. They have counterclaims now, so you're going to hear counterclaim plaintiff and counterclaim defendant, cross-complainant, cross-defendant. So let's try to just forget about that for right now. Twitch operates an online platform. Varga is a professional video game player who streamed gameplay on Twitch. The issue presented is whether a limitation of liability clause in the agreement between Varga and Twitch is unenforceable. Varga presents 3 bases for his position, which could limit his recovery to $50,000. He presents 3 bases that clause is unenforceable. It's unconscionable, it violates public policy, and it is an unreasonable liquidated damages clause. This is actually really interesting contract stuff because we don't get to see too many cases where a judge decides that something is unconscionable and just throws out a whole part of the agreement. So let's keep going. Varga signed his agreement with Twitch in November 2012. Varga was one of the top live streamers. His account was one of the top 25. He was operating his own 3D platform. The title of his platform was Own 3D, using the alias PhantomLord and working about 90 to 120 hours a week. Holy mackerel. No wonder we're not successful. I can't put in 90 to 120 hours a week. Jeez. His compensation, as is typical for live streamers, was a combination of advertising revenue, sponsorships, and donations. By November 2012, he was owed almost $8,000, but it is not apparent that Varga thought Owned, I think it's just Owned, was in serious financial difficulties or about to go under. By December, 2 people well known to Varga had left Owned and moved to Twitch, Stuart Saw and Jason Opie Babo. Around December 14th, they called Varga and told him Owned was failing and invited him to join Twitch. The parties disagree whether Saw and Babo told Varga they were in fact already at Twitch or whether Varga's contemporaneous email to his brother suggests that they were going to Twitch and had not yet moved. It doesn't matter. In any event, Saw and Babo were clearly lauding Twitch and casting aspersions on Owned. Their loyalties had overtly switched to Twitch. Under the circumstances, which included Babo and Saw making an offer with specific numbers for revenue sharing and other terms, I do not credit Varga's testimony when he said he had no idea that Saw and Babo were speaking to you on behalf of Twitch, if what he meant was he did not think they were presenting an offer from Twitch. Saw and Babo told Varga that Owned was in effect coming apart and offered him a contract with Twitch. I infer that Varga thought accurately that Saw and Babo were authorized to make him the offer because Varga testified that he accepted their offer then and there. Whether he did, in legal fact, then accept the deal is a distinct matter. For now, the point is simply that Varga must have thought Saw and Babo were agents for Twitch. On the call, Saw and Babo offered to have Twitch pay the almost $8,000 Varga was owned by Owned, a percentage of the advertising revenue stream, a certain sum per number of visitors to Varga's streams, and other terms. The parties disagree on whether Varga in fact negotiated the final financial terms. Twitch says Varga negotiated and got better than the original offer, and Varga says he was presented with those terms. After the call, Varga sent his brother an email on the deal asking him, "Tell me what you think." 2 days later, Varga got the written agreement from Twitch. During that interim period, he considered what to tell his fans and other issues related to the move, including doing my research. And while he says he felt pressured to sign, it was Varga who called Twitch to find out where the contract was. 2 days after his call with Babu and Saw, Varga on November 16th was in contact with Twitch's John Howell asking for the agreement. Later that day, Howell sent him the agreement via the HelloSign site. As the last page of Exhibit 50 records, it was provided to Varga at 3:35 Universal Mountain Time. Varga viewed it a minute later, then signed it 33 minutes later. The agreement is 16 pages with 2 sections in all capital letters, the disclaimer of Section 7.4 and the limitations of liability section issue now, Section 8.4. The HelloSign site presented the agreement with a signature page first. One may scroll down to see the rest of the pages. Varga did not scroll. He isn't sure what he was doing during the time he first accessed the agreement to the time he signed it, perhaps playing a video game. He could have reviewed the agreement, but he did not. Always review your agreements. The agreement's term was 2 years. It would expire in November 2014. Many months before that, on April 2nd, 2014, Varga was sent via HelloSign an amendment, a 2-page document, which in effect extended the agreement for another 2 years. No one was in a rush to get this done. It was, after all, more than half a year before the agreement was to expire. Varga eventually got around to signing on April 24th, and during that time period discussed the agreement with no one at Twitch and did not review the agreement itself. Always review your agreement. Although Twitch did not enclose a copy of the original agreement with the amendment, it was always available to Varga. Indeed, he retrieved it to produce it in this litigation. Varga signed the agreement within a minute of opening the document. The HelloSign mechanism was the same as it was in 2012 and 14. One may scroll through the document, etc. The unconscionability argument. The overarching unconscionability question is whether an agreement is imposed in such an unfair fashion and so unfairly one-sided that it should not be enforced. As our Supreme Court has recently reminded us, unconscionability has 2 aspects: a procedural element which looks to the circumstances of contractual negotiation and formation, focusing on oppression or surprise due to unequal bargaining power, and substantive unconscionability, which pertains to the fairness of an agreement, to the actual terms, and to assessments of whether they are overly harsh or one-sided. We are to balance these aspects. If there is less evidence of one, there must be more of the other in order to find unconscionability. Varga has the burden of establishing unconscionability. An initial inquiry is whether Varga was presented with a take-it-or-leave-it contract, a contract of adhesion in the context of an imbalance of power. Employment agreements are typically contracts of adhesion, but the agreements in this case were not employment agreements. Whether the contracts were presented on a take-it-or-leave-it basis is fact-specific here. Varga says he didn't know he could negotiate, and Twitch said he could have done so, and indeed did so. Adhesion is also a function of the degree to which Varga had meaningful choice. In 2012, Varga could have continued with Owned. To be sure, he was told by Saw and Babu that Owned was on its way out, but that was not clear at the time. Some thought Owned would survive, others didn't. There were alternatives at the time, mentioned in Twitch's closing brief, but none compared to either Owned or Twitch, and I find they were not practical alternatives for Varga. On balance, because 1, it's clear that Babu was, on the basis of a relationship of many years, fully trusted by Varga. 2, Babu and Saw on the November 2012 call went quite out of their way to induce Varga to believe that Owned was doomed. And 3, as upper-level employees of Owned as they had been, Saw and Babu would have appeared to Varga to be in a position to know Owned's prospects. I find that Varga reasonably thought that he would have had to sign on with Twitch, but only at some point in the foreseeable future and not necessarily at the very moment he signed the agreement. Twitch could have survived without Varga. Varga reasonably could have concluded, and probably did as a result of his call with Saw and Babu, that he could not thrive for long without Twitch. This weighs in favor of a finding of oppression. Also relevant to the issue of relative bargaining power was the extent to which Varga was popular, in turn a sign of how economically attractive he was to Twitch, and so a measure of the extent to which he could have leverage in bargaining. It isn't entirely clear how relevant this inquiry is, because while Varga was aware of his standing, the number of fans he had, and the like, he didn't seem to understand, either in 2012 or 2014, the fact that his status could be used to negotiate favorable terms with Twitch. In addition, the bargaining power that he did have in both 2012 and 2014, even though it was not consciously used by Varga to secure good financial terms, did in fact result in him getting apparently what were the best terms available. All right, let's skip ahead a little bit here. The adhesion issue is made difficult for two reasons. First, while Twitch tells me all of the terms are subject to negotiation, Twitch didn't present any contracts with other streamers, much less any differing terms, even though it was within their power to do so. Second, as I have just noted, even though he knew he was a sought-after player in 2012 and in 2014 knew he was at or near the top of his profession, Varga says he did not seek to negotiate, and indeed Varga was so uninterested in the terms of his contracts, both in 2012 and 2014, that he never read them until this litigation. Indeed, he didn't even look at the financial terms. It appears that even had he tried to negotiate at least the financial terms, he would not have made much progress because he got the best deal there was. I conclude under these unusual circumstances, where one, a party had bargaining leverage he did not understand, and even if the leverage was exercised, it is likely would have made no difference to the financial terms, and the party was under the reasonable impression that Twitch was his only choice, that the contract was in effect one of adhesion. This suggests some procedural unconscionability. As to oppression, we also look to the amount of time the party is given to consider the contract, the amount and type of pressure exerted on the party to sign the proposed contract, the length of the proposed contract and the length of the complexity of the challenged provision, the education and experience of the party, and whether the party's review of the proposed contract was aided by an attorney. In brief, Varga had plenty of time to review the agreement. The agreement is of moderate length, and Varga has not suggested the provision at issue was too complicated to understand. Varga had some college education, had been in contractual relationships before, such as with Owned and others, but as I note below, there was significant disparity in legal sophistication, and Varga did not use an attorney. These factors on balance suggest some oppression. Finally, the parties had a significant difference in their legal sophistication. Varga was 26 years old and living with his parents and has no legal experience. Twitch had retained a lawyer to draft its form agreements, including the one at stake now. This tends towards a finding of oppression. The next issue to consider is surprise, where the allegedly unconscionable provision is hidden within a prolix printed form. This quality is not a function of the length of the agreement, rather it pertains to the context of the provision at issue, where the format and wording of the surrounding text aids its hiding the provision. So in OTO, I believe that's a case, the form was prolix because it was written in an extremely small font. Okay. There is something odd about Varga's argument that there was surprise when Varga never even attempted to review the agreement, and indeed, to the time of trial, never had. The agreement is about 16 pages, the font is small, but the capitalized wording of section 8.4 is noticeable even on a quick scan of the pages one might do simply to get a sense of the overall content or structure of the agreement. The language of the agreement in some places probably obscures to a layperson, such as 113 on restrictions and 8.3 conditions of indemnity, and some provisions need at least a few readings to get a rough meaning, such as section 6 on confidentiality. But Varga does not actually argue that any particular language is impenetrable or illegible. He still has not read the agreement, and he could not testify that any language was particularly obscure to him. Rather, Varga argues that section 8.4 is hidden because it is just past the middle of the agreement. But of course, some language must be past the middle of any agreement. There is either no or an extremely low level of surprise here. Reviewing both oppression and surprise, there is some procedural unconscionability based on the oppression factor. And the judge is going to go over to substantive unconscionability. which addresses the fairness of the term in dispute traditionally. It involves contract terms that are so one-sided as to shock the conscience or that impose harsh or oppressive terms. Varga argues that there are 3 one-sided provisions here. Varga cannot recoup money owed to him over $50,000 even if he proves the loss. Confidentiality and indemnification exclusions benefit Twitch but do not benefit Varga. And the definitions of gross revenues protect Twitch's interest at Varga's expense. As to the first issue, Varga is correct. Twitch promised to pay money to Varga. Were Twitch to fail to do so, Varga would be unable to collect more than the $50,000 limit. Varga's monthly income averaged over $5,000 per month and appeared to cluster around $10,000 per month, so the $50,000 cap is so incommensurate as to be unconscionable. Twitch's response is that this is a hypothetical issue that does not affect this litigation. Twitch argues this in connection with all 3 provisions discussed in this section. I discussed that separately below. As to the second issue, it is true that the provisions conceivably might benefit Twitch more than Varga, but the result is reasonable. In fact, there was no substantial evidence that Twitch gave Varga confidential information or that the parties contemplated it might do so. If Twitch did, it was the compensation packages which were disclosed in this case. Varga likely gave Twitch some confidential information on his bank account in order to enable payment. As to indemnification, the protections correspond to the services and products which each side brings to the table. Varga indemnifies for legal problems with the content he creates, and Twitch indemnifies for legal problems, essentially intellectual property issues, which its software and site might create. A reason for one-sidedness cuts against the finding of substantial unconscionability. As to the third issue, Varga notes that gross revenue does not include fraudulent payments and chargebacks, so instead of suing Varga for the return of sums it paid attributable to the fraudulent gross revenue, Twitch might be able to set off those sums against Varga's future earnings. As to all 3 issues discussed above, Twitch argues that the claimed substantively unconscionable consequences are not involved in this case and hence should not figure into my determination. Twitch cites 3 cases, and the cases are Olsen, West, and River Island. Olsen's statement is the best dicta, which means not binding precedent. The court discussed contracts skiers were expected to sign releasing ski rental companies from liability. By the time the court reached unconscionability, it had already decided the releases at stake were reasonable and then went into this dicta. This is not to say that under appropriate circumstances, we would not find a broadly or vaguely worded release unconscionable. However, such a determination must await those circumstances. Courts do not render advisory opinions. Courts deal with actual, not hypothetical, controversies. All we conclude here is that it is not unconscionable for ski equipment distributors and retailers to require the use of releases at issue as a condition for doing business with them. It is not clear what the court means here, but in context it seems as if it might refer to a situation where a skier was surprised by the release, contrary to the court's view that skiers would generally not be surprised at all. West is not more helpful. The court there didn't quite hold that a hypothetical unconscionability should be considered. Rather, it held that if an unconscionable result were to occur, a trial court could deal with it by severing out the offending provision. Zaborowski doesn't seem to be on point at all. It faced 2 alternative readings of a contract and decided to follow the most reasonable one. A proper approach to the hypothetical unconscionability hinted at in Sanchez v. Valencia is that a court may evaluate the reasonable likelihood of a procedural posture and measure unconscionability from that vantage, regardless of whether the specific case before the court actually involves such a posture. The issue is, what are the likely risks borne by the parties as of the time of contracting? We agree with Valencia, quote, that the appeal threshold provision does not on its face obviously favor the drafting party, assuming as the parties do the likely scenario of the buyer as plaintiff and the seller as defendant, the unavailability of appeal from an award that is greater of 0 but not greater than 100,000 means the buyer may not appeal from a non-zero award that he or she believes to be too small, nor may the seller appeal from a substantial award up to 100,000 that it believes to be too big. It may be reasonable to assume that the ability to appeal a $0 award will favor the buyer, while the ability to appeal a $100,000 or greater award will favor the seller, but nothing in the record indicates that the latter provision is substantially more likely to be invoked than the former. We cannot say that the risks imposed on the parties are one-sided, much less unreasonably so. The $50,000 cap in the limitation of liability clause is unconscionable. Independently, it does not affect claims for intentional misrepresentation, negligent misrepresentation, and the Businesses and Professions Code. My final statement of decision will set a case management conference to discuss the next steps in the case. So that doesn't mean that PhantomLord has won his case, but it does mean that he's allowed to continue pursuing his case, and he is no longer limited by the $50,000 liability limit, which is really cool. And you saw some of the arguments for and against unconscionability in that clause, that Twitch and he had a unequal bargaining position, that he may have been coerced into believing that his company was going under by agents of Twitch. And then the little bit of procedural unconscionability caused by that was then pushed over the edge, or pushed over the tipping point, by the simple fact that a $50,000 cap was very one-sided and didn't seem to allow Twitch to suffer any actual damages beyond $50,000, even if it caused more than $50,000 worth of damage. So that's more or less why it was unconscionable. I understand that that's clear as mud. Some of that was very gooey and not very clear at all. So definitely let us know what you think, and let us know your thoughts and questions in the comments below. We'll keep an eye on the PhantomLord lawsuit and keep you updated. So that's our show, everyone. Thanks for joining me. I am Leonard French, your favorite copyright attorney. With me in the studio was Brandon and Tactical. I think Blackleaf and Tau are here as well, but they didn't say anything. Thank you very much for your support on patreon.com/ljfrench and sponsus.com/law. Thank you to our channel supporter for the month of October. Thank you to Joshua Davis from TandaPay. Thank you to our $50 plus supporters: Joe Tyson, Aspernari, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Snorre Wisotzky, Joe Tyson, Blackleaf, and Benjamin Hitov. I think I'll have to work on that one. I think Joe Tyson showed up twice there. So good for you, Joe. I think you even warned me about it. I did it anyway. And thank you to the $5 plus supporters who are scrolling on the LED panel behind me, and will be on the crawl of the outros of the videos. So the dogs have gone and laid down. Instead, what I'll do is put some dog video in the outro here for you. So thank you for watching. I am Leonard French, your favorite copyright attorney. Have a great week and a great weekend. Love you all. Bye.